Okay, so we are continuing with the Companies Act requirements. Okay, so we're still on chapter 2, the governance of companies. Okay, we've covered governance by shareholders. Now we're going to look at governance by the directors of the company. Okay, so section 66 talks about 268 talks about boards, the directors and prescribed officers. It details the board's responsibility and the minimum number of directors. For private and personal liability company, that is 1, but if you are a public company and you're a not-for-profit company, then you at least need 3 as the minimum number of directors. Okay, however, the MOI may specify a higher number of directors. Okay, but do note that the failure to meet the minimum requirement of directors does not in any way limit the authority of the board or invalidate any decisions that were taken by the board. Okay, the person who incorporates the company, okay, who sets up the company, okay, as a legal person, as a juristic person, that is the first director. Okay, directors could serve an indefinite term, okay, or term set out in the memorandum of incorporation. Okay, thereafter, directors need to be appointed by the shareholders, and they need to at least have passed an ordinary resolution, i.e. 50% of the votes need to be passed in favor of the directors. Okay, so for directors' remuneration, directors need to be paid for their services as directors. Okay, just remember that we have executive directors, okay, which are employed by the company. Okay, and then you have non-executive directors who may or may not receive an attendance fee at for attending board meetings. But do remember that the memorandum of incorporation could specify otherwise. Okay, this director's remuneration, it needs to be approved via a special resolution. Okay, in terms of section 69, it talks about the ineligibility and disqualification of directors. These are persons which are not allowed to be directors of a company. Okay, you could be ineligible. For example, this is a juristic person, i.e. a company cannot be a director of another company. Okay, or it is a minor who cannot then act as a director, or a person who is legally incapacitated, or any other person in the MOI. That is for someone who is ineligible, i.e. he cannot be a director inherently. Okay, but for persons disqualified, this could be someone that is prohibited by a court to be a director. He is an unrehabilitated insolvent, or someone that has been removed from an office of trust on the grounds of misconduct or dishonesty, or someone that has been convicted and imprisoned without a fine, so that disqualifies you from being a director. Okay, in terms of filling the vacancies on the board of directors, could be by a new appointment as per the MOI, or an election at the next AGM. Okay, so if there is no AGM requirement, okay, remember the requirement to have an AGM is only there for public companies. So if you are a private or a personal liability company, you could then fill the vacancy within 6 months at a shareholders meeting or via the poll. Okay, the shareholders meeting is just a general shareholders meeting. It's not the annual general meeting. Okay, and then this notice of the election or the filling of the vacancy needs to be filed within 10 business. Okay, in order to remove a director, you need to comply with the requirements of section 71. Okay, so a director may be removed by an ordinary resolution. Okay, so just take note of the fact that it does not require a very high percentage of votes to be able to remove a director. Okay, if the company has more than 2 directors and a director or shareholder alleges that a specific director is not eligible or incapacitated or has neglected their duties, then in terms of a board resolution, this director can be removed, but he could also apply to the court to review the decision. Okay, In terms of the removal, sufficient notice of the meeting has to be provided to the affected director, and he should then be allowed to make a representation of his case at the meeting before the removal or the voting of the rules. Okay, so for board committees, the committees may include a person who is not a director. Okay, the committees may consult, okay, or receive advice, and then they do have full authority by the board. So the board can delegate their powers to the committee. Okay, so except if are not provided for such as per the MOI. Okay, for public company, okay, we require a social and ethics committee if it is in public interest. Okay, section 73-74 talks about board meetings. Board meeting may be called by a director at any point in time, or 25% of directors if the company has at least 12 directors. If the company has at least 12 directors, then at least 3 directors need to call the meeting, or then 2 in any other case. Just remember that the MOI may also amend these numbers to be higher or lower. Okay, board meetings may be conducted electronically, or you may be able to participate electronically. That is fine. However, do note that minutes need to still be kept. Resolutions that are taken at these meetings need to be dated and numbered, and they are effective from the date of the resolution unless it is otherwise specified. Okay. Except if the MOI provides otherwise, a company that fails to give notice of the meeting, okay, or if there's any defects in the notice, okay, it was not sent out within sufficient time, or any other defects, the meeting may proceed if all of the directors agree. Okay, so it could still continue. Okay, and the majority of the directors are present before the voting begins. Okay. Each director is allowed 1 vote, and a majority is then required for the decision to take effect. Okay, so that more than 50%. Okay, that is an ordinary resolution, and then the chair of the meeting has the deciding or the casting vote. Okay, so very important section again, highly examinable, section 75, directors, direct or indirect personal financial interest. So if a director has a personal financial interest in a specific matter or contract that needs to be discussed at the board, or not only those that need to be discussed at the board, but in specific matters relating to the company, he needs to give advance notice thereof. He needs to disclose this in advance to the board. Okay, and he needs to disclose the nature and the extent of his interest. What is the interest, and how much is it for? Okay, so at the board meeting, he discloses the nature and the interest, okay, and the extent of the interest, and any other material information. Okay. He may also disclose any other observation or pertinent insight in terms of the matter, okay, but that is not a must, it's a may. Okay, after the disclosure, he needs to leave the meeting, okay, and he may not take part in the voting on the matter. For the purposes of determining whether quorum was present in order to constitute a valid meeting, he forms part of the quorum, but he does not form part of the percentage if a resolution needs to be adopted. Okay, so in counting whether there's 50% of votes, he may not vote, so he does not form part of that quorum for voting. Okay, he may not execute any document on behalf of the board on the matter unless he is specifically requested to do so by the board. Okay. So he needs to disclose the nature and extent of the interest to the board. If any transaction, okay, so if he acquires the interest after the decision has been taken, he needs to disclose that nature and extent to the board and shareholders. Okay, that decision or transaction or agreement is valid if it is approved by the board after this disclosure has been made, or it is ratified by the shareholders or by the courts. Okay, if there's only one director the company and he has a personal financial interest in this matter, then the matter needs to be approved by the shareholder. Okay, section 76, standards of directors' conduct. A director of a company must not use their position or any information obtained within their position to gain advantage for him or herself or any other person. He may not knowingly cause harm to the company or subsidiary, and any information that may be disclosable or relevant information needs to be communicated to the board as soon as it becomes available to him. Okay, he needs to exercise his powers and functions within good faith, in the best interest of the company, and with the required care, skill, and experience that is required of a director. Okay, he may rely on information obtained and responsibilities performed by reliable and competent employees that provide him with reports, with information, for example, or legal counsel, accountants, consultants, any other professional person, or he may rely on the information and responsibilities that are performed by the committees of the board, where so delegated. Okay, so again, 77, liability of directors, highly examinable as well. A director may be held liable for loss or damage or cost sustained by the company if he breaches his fiduciary duties, okay, where he does not act within the best interest of the company, or he does not act with due care and skill, okay, or where he breaches any provision of the Companies Act. He may also be held liable. Okay. He's also held liable if he acts in the name of the company without the appropriate authority to do so. Okay, where he carries on business recklessly or under insolvent conditions. Okay, where he is part of an act of omission intended to defraud creditors or employees or shareholders for fraudulent purposes. Okay, so where they withhold information for the purposes of defrauding creditors, employees, shareholders, and other stakeholders. Or he signs or approves the publication of the financial statements that he knows has false, misleading material information, or a prospectus that is issued for the purposes of issuing new shares, but that prospectus has untrue or false or misleading statements. Okay. Or he could also be held liable where he's present at a meeting and he fails to vote against a contravention of the Act. Okay, indemnification of directors. Okay, any provision of the MOI or rules or any agreement is void that relieves directors from their fiduciary and statutory duties, or any such provision that tries to limit the liability of directors. Okay, that would then be void. Okay, so that is then not allowed. Okay, however, the company or the director himself could obtain insurance against losses. Okay, so his liability may not be limited, but he is allowed to obtain insurance to be able to cover him should he be held liable in certain respects. Okay, so 79 to 84 talks about winding up of companies, of solvent companies. Company may be wound up, okay, or liquidated by voluntarily by special resolution of the shareholders, or it could be in terms of a court order. Okay, so chapter 3 talks about accountability and transparency. Okay, so in terms of section 84 to 85, a public or a state-owned company must appoint a company secretary, an auditor, and an audit committee. Okay, so in terms of 86 to 89, it talks about the appointment of a company secretary, the duties of a company secretary, that is to assist the company in carrying out their statutory and their compliance requirements. Okay, so the company secretary enables and assists the company to meet their compliance requirements and assist the board in fulfilling their duties. Okay, so a company secretary can be a juristic person. It could be a company. Okay, so sometimes one of the audit firms acts as company secretary for certain public companies, listed companies especially, like to use the audit firms. Okay, if the company secretary resigns, at least a 1 month's notice is required. Okay, section 90 talks about the appointment of an auditor, which is a requirement for a public and a state-owned company. Okay, so within incorporation, at least within 40 business days, an auditor needs to be appointed. Thereafter, every year at an AGM, okay, within 40 business days of the AGM as well. Or you could just decide to reappoint the same auditors. That is also possible. Okay, a person or a firm could qualify to be appointed as an auditor. Person if it is a registered auditor, and a firm who has a registered auditor. Okay, so in terms of the resignation and vacancy, an auditor is required to give 1 month notice to resign. He could give less if that is approved by the board. Okay, so a vacancy within 40 business days, if a vacancy exists, a vacancy for the auditor exists, okay, within 15 days, business days, a proposal needs to be made to the audit committee to name at least 1 registered auditor to be considered. Okay, then they have 5 business days to object that, but the vacancy needs to be filled within 40 business. Okay, so section 92 talks about rotation of auditors. The same individual is not allowed to serve as auditor for more than 5 years. However, the firm that individual belongs to can still remain as an auditor. However, the partner needs to then rotate because he's not allowed to be the auditor for more than 5 years. Okay, so 93 talks about the auditor's rights. The auditor has the right to access all the accounting records, books, and documents, to obtain information and explanation from directors, to attend shareholders' meeting, okay, and also to communicate with the auditor of the holding company. Okay, so section 94 is the requirements for an audit committee. Okay, remember we said that public and state-owned companies must have an audit committee. Okay, any other company can voluntarily elect an audit committee. The audit committee is elected then at the AGM. Okay, it needs to have at least 3 members unless this company is a subsidiary of another company that has an audit committee. Then it could decide to have less members of the audit committee, or it could be that the holding company's audit committee then acts as the audit committee of this company as well. Okay, so the first members of the audit committee are appointed by the incorporators of the company or by the board within 40 business days of being incorporated. Okay, once again, a vacancy on the audit committee needs to be filled within 40 business days after the vacancy arises by members of the audit committee. Okay, the members of the audit committee need to be independent, non-executive directors. Okay, and then the duties are similar to what is described under the King report, deciding on the auditor, agreeing on the scope of an audit, and dealing directly with the chief audit executive, that is the head of internal audit of a company, and then dealing with the auditors, the external auditors as well. Okay, so chapter 4 talks about public offering securities. Okay, just do note that public offering of securities needs to happen within the ambit of a prospectus. This prospectus is a document issued by the company that details all of the specific requirements for the issue of shares. So the issue of shares needs to take place within the ambit of a prospectus. Okay. Chapters 5 talks about fundamental transactions, takeovers, and the important section here is section 112, which is a proposal to dispose of all or a greater part of the company's assets or undertakings. Okay, so this needs to be approved by a special resolution of the shareholders, where the company tries to dispose of all or a greater part of its assets. Okay, court approval needs to be obtained if 15% or more of the shareholders have opposed this disposal of assets and other undertakings. Okay. Or court approval can also be sought by any person who voted against the resolution. Okay, so the notice of the shareholders meeting where this is being decided upon, where this resolution needs to be taken, that notice needs to happen within a prescribed time, within the prescribed manner, and then a written summary of the precise terms of the transaction need to be included in that notice. Okay, part of the undertaking or assets that need to be disclosed, that is considered at its fair market value at the date of proposal. Okay, so to determine whether it is all greater part of the assets or undertaking, okay, that part needs to be considered in terms of the market value in relation to market value of the existing business and assets of the company.